Hello everyone, my name is Yingtong O. I'm a bachelor student at Beijing Foreign Studies University in Beijing, China, and I'm now majoring in Thai language. So today I will introduce a law in Thailand first, and then discuss the topic about whether restriction on foreigners' employment will violate the principle of equality and non-discrimination or not. Now let's begin. In this talk, I would introduce a law which concerns the employment of foreigners workers in Thailand, which is called the Thailand Foreigner Working Management Emergency Decree. Next, I would like to show how the principle of equality and non-discrimination will be used in the theoretical and practical field, which also include the employment discrimination. After that, in part 3, the method to judge whether the employment discrimination exists will be presented. Last but not least, focusing on the Thailand decree, whether the restriction on foreigners' employment will violate the principle of equality and non-discrimination will be discussed. First of all, let's imagine this. If you want to work in another country, also a good company in that country offer you a suitable job. You are very glad about that. However, when you are going to apply the visa, the officer told you that you can't apply for this, for you are a foreigner and have no right to work in this country. What would you think? Would you think it is fair? This is exactly what we will discuss today. In Thailand, the government issued the Thailand Foreigner Working Management Emergency Decree in 2017, and its Section 59 sets up a strictly restricted job list for foreigners, in which 27 occupations are strictly prohibited for alien workers, ranging from public transport driver to the painters, auction practitioners. Therefore, we are going to mention the principle of equality and non-discrimination. Actually, there are a large number of international treaties to against discrimination, like the Charter of the United Nations and the Universal Declaration of Human Rights. The international treaty above all determined to promote equality without discrimination in all respects. Employment is also included. Actually, early in 1944, the Declaration of Philadelphia have emphasized that all human beings have the right to pursue both the material well-being and the spiritual development fairly. Later, the Convention Concerning Discrimination in Respect of Employment and Occupation, which issued in 1958, also mentioned the same things. Based on this, employment discrimination has the following two characteristics. First, there exists differential treatment. Second, there is no justifiable reason for the existence of differential treatment. After understanding the definition of employment discrimination, how can we judge whether there exists employment discrimination? According to the General Comments number 18, Non-discrimination, as long as the differential treatment is reasonable and objective, the behavior will not be considered as discrimination. However, how can we judge it? Then we can turn our eyes to the case of Origin and Kites versus the Netherlands. In this case, the United Nations Human Rights Committee, HRC, which is responsible to handle the international case about discrimination, adopted the concept of sense of proportion, which means if the behavior is reasonable and objective enough, then the differential treatment will not constitute the discrimination. However, sometimes we may be partially subjected. Therefore, the proportionality principle, which focuses on the essential relationship between the method and the purpose by considering appropriateness, necessary, and concretization, can be used together with the sense of proportion to judge whether there exists employment discrimination. Next, we will analyze the restriction on foreigners' employment in Thailand decree. According to the definition of the employment discrimination, the existence of differential treatment should be discussed first. The prerequisites for differential treatment is the existence of similar or the same situation. Then we can focus on the Labor Protection Act of Thailand, which enjoy a higher legal hierarchy than that of the Thailand Foreigner Working Management Emergency Decree. In the Labor Protection Act, it stipulates that all employees shall be treated properly in accordance with the rights and duties by the labor law, and the employee means a person who agrees to work for an employer in return for wages, regardless of the name used. Therefore, regardless of whether the worker have Thai nationality or not, as long as they are accept legal employment, they will show equal status in the legal sense of Thailand and enjoy same rights. Therefore, there exists differential treatment. Next, the rationality and objectivity of differential treatment should be discussed. We will apply the proportionality principle, which can be divided into three sub-principles, which is appropriateness, necessary, concretization. First of all, we must clarify the goals and mean of the decree. The decree aims to increase employment opportunity for Thai nationals and ensure employment in Thailand by using the means of restricting alien workers for apply for some certain jobs. As one of the sub-principles, the appropriateness emphasizes the relationship between legislative means and legislative purpose, reviewing whether the means can achieve the intended purpose. Generally speaking, a legislative purpose can often be achieved through a variety of methods. By prohibiting alien workers to apply for some specific job, definitely can provide more jobs for local people in Thailand. Therefore, the restriction is appropriate. For the sub-principle of necessary, it refers to the legislative authority choosing a means that least infringes on the rights of citizens among the means that can all achieve the legislative goal. However, restricting alien worker employment is not the only way to protect the employment of Thai nationals. Other methods such as restricting the industry or increasing public projects can also be adopted. Regarding of the infringement of the counterparty rights, restricting foreign workers from engaging in specific occupation harm the right of the foreigner to freely choose their job and other human rights such as freedom of expression. In contrast, other methods such as promoting innovation and entrepreneurship will not cause obvious damage of the rights of foreign workers in Thailand. For the sub-principle of concretization, if a mean will cause unnecessary harm to the counterparty, and this kind of harm exceeds the value of the legislative purpose, then the use of the mean does not comply with the principle of concretization. To quantify the concretization principle, German scholar Robert Alex proposed the law of balancing and the weight formula. After taking the right that protected and infringed, the importance of the right, and the possibility to achieve the goal into account, it is found that restricting foreign workers to freely choose their employment has no benefit enough for the protection of Thai national employment. In conclusion, although the decree aimed to increase employment opportunity for Thai nationals, it treats Thai workers and foreign workers with equal legal status in Thailand differently by prohibiting foreign workers from engaging in specific occupations. Meanwhile, it failed to fully meet the proportionality principle. Additionally, there is no justifiable reason for differential treatment. Therefore, the Thailand decree violates the basic connotation of the principle of equality and non-discrimination in international law and constitutes the substantive employment discrimination. That's all my presentation. Thanks for your listening.